Guess who's back? Back again. If you know, you know. Hello, my friend. It is Perez, the queen of all media, the original influencer, and your number one source for everything. It ends with us, saga. Today is one of my favorite days. I've said this before. My job is like that of a professional surfer. If you love what you do, you will get out there and ride the waves, even when you have big waves or small waves or no waves at all. But today, we got a lot of action in the ocean. I am in a mood. In case you missed it, earlier today, Steak Lively's legal... Steak Lively? Steak Lively. You know, because she's got beef with everyone. That may not be a keeper. Steak Lively, you like it? Earlier today, Steak Lively's lawyer, ethically challenged Ezra, was bickering with Team Wayfarer over documents. Many exhibits they filed under seal last week in their motion for summary judgment. Briefly, the MSJ, that's just saying to the judge, yo, you should dismiss this now because based on all of the evidence, what we are telling you is undisputed. These are facts. This is what happened. And per the law, you don't even have to present this to a jury. We win. And because they filed dozens upon dozens, well over 100, I forget the exact exhibits, Team Caca Ridicula Diabla Rubia is not happy with the current schedule to keep certain things sealed. Translation, Baseless Blake wants to keep information hidden from us, even though the Wayfarer defendants had agreed to redact personally identifiable information. Phones, email addresses, home addresses, you know, the things that they did not redact over and 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 over again. The executor of extortion's attorney was boo-hooing over the lack of professional courtesy by the Wayfarer parties for not agreeing to an extension for her seeking continued sealing. Oh, you know, this just reminds me of when they were trying to serve the Wayfarer parties when the fires were happening in Los Angeles. So, belligerent Blake went to the judge earlier today saying we need and should have more time. Well, now, Wayfarer has responded to that and we've gotten another order from the judge. A 2-in-1 video. Oh yeah! I told you, a lot of waves today. Yes, I did just have a pre-workout drink. And I'm not going to the gym. I'm doing this. This is my workout. Oh my God. It's a good workout. Thank you for watching my videos. Truly. Thank you. Gracias. Merci. Danke. I am a dork. But I love what I do. Still, I'm grateful. I don't want to work as hard as I do when I'm in my 50s, but I got another 2 years left until 50, and then life changes a lot when you hit 50. Anyway, sidetracked, back to the saga. We will get to the judge's ruling on Signalgate. Remember that? But first, Alexandra Shapiro, the boss babe herself, the person who authored the motion for summary judgment, took the lead in this response to Judge Lyman. She says, quote, Dear Judge Lyman, the Wayfarer parties, Wayfarer Studios, LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie, LLC, Jennifer Abel, Melissa Nathan, and TAG, respectfully write to oppose Lively's request for a multi-week extension of her time to file motions to seek sealing of summary judgment materials. As Your Honor well knows and has stated in prior orders in this case, the Supreme Court and Second Circuit have long held that there is a presumption of immediate public access to judicial documents under both the common law and the First Amendment. This presumption is especially strong where the materials are filed in connection with summary judgment, as is the case here. I haven't even read this letter in full yet. I am getting to it in real time along with you, but what our girl Alexandra is, I think, setting the stage for is painting the picture that self-defaming Serena, like I said, is trying to keep a lot of important evidence that helps Baldoni and team. She is trying to keep that hidden. No. The public's right of access cannot be needlessly delayed, says Shapiro. For the right of access to justify its purpose, it must be a right of timely access. Accordingly, the Second Circuit has warned that each passing day may constitute a separate and cognizable infringement of the First Amendment, and long delays in adjudication based on secret documents impede the public's ability to properly monitor the work of the courts. As Lively notes, the Wayfarer parties have no objection to a 1-week extension, doubling the time allotted under Your Honor's individual practices. Footnote: the Wayfarer parties have also offered to handle redactions of personal identifying information on any document that is unsealed before refiling. Any further extension beyond 1 week is wholly unnecessary and would contravene Second Circuit law. Lively's lengthy letter does not even acknowledge this clear and binding precedent, and she certainly provides no compelling reason to depart from it. Lively complains about reviewing 100 exhibits for various reasons, including that they were provided to her 2 hours after midnight instead of at midnight on the dot. But the documents at issue do not require any detailed analysis. They are not trade secrets or technical documents or customer lists. They are primarily emails and text messages for which there is no colorable? Fudge. Colorable? Is this a typo? Is this a real word? Let me look at it. COLORABLE. It's a real word. Colorable. Oh my God. Oh my God. It's spelled fanatic. My pre-workout drink is pre-workouting. Colorable, capable of being colored, apparently correct or justified. The over 100 exhibits are primarily emails and text messages for which there is no colorable basis to seal, which is precisely why the Wayfarer parties have unsealed all of their own comparable materials. Many of these documents should come as no surprise to Lively, as they were used as deposition exhibits and even as the basis for her own pleadings. Moreover, no one can dispute that Lively, who is represented by numerous global law firms, has numerous lawyers available who are intimately familiar with the facts and could promptly conduct a review. True. True. To my knowledge, she has at least 3 law firms: Wilkie, Manat, Dunn Isaacson, also one in Florida, I think. A lot. Ryan's money. Lively also claims a further extension is needed to accommodate various third parties. Not one of those parties has asserted any need for any further extension themselves. No doubt because no third party has more than 25 documents to review, and most have far fewer. This is all about her and trying to keep facts, receipts, proof, timeline, screenshots, evidence hidden. Okay, I might have a heart attack. Lively's account of the negotiations around the issues also conspicuously omits the history of the parties' discussions on this issue, which suggests that details such as the number of exhibits involved and when exactly they were served are not the true basis for Lively's extension request. In particular, Lively fails to acknowledge that she proposed the same extension of sealing to the Wayfarer parties even before any summary judgment motion was filed, and before she knew how many exhibits might be sealed or what time they would be served. And although the Wayfarer parties believed, based on the parties' earlier discussion of the issue, that Lively would be filing a summary judgment motion of her own, the Wayfarer parties still rejected her proposal, explaining that it was inconsistent with Second Circuit law and the public's right of access. In other words, the Wayfarer parties were willing to adhere to the same time constraints for sealing motions themselves. Notably, since the Wayfarer parties filed their summary judgment motion a week ago, Lively's counsel has made no effort to have any meet and confer concerning the substance of any document that they maintain should or should not be sealed. Whatever the reason for Lively's dilatory tactics, her request for further extensions cannot be squared with Second Circuit law and should be rejected. Respectfully submitted, Alexandra A.E. Shapiro. And now let us jump to the judge's ruling on Signalgate. Dong, dong, dong. Unrelated to the extension drama. Unseal it all. My former arch nemesis, Judge Lyman, writes, quote, Plaintiff Blake Lively seeks an order directing the Wayfarer parties to produce certain documents identified on their signal privilege log. Signalgate has been one of the biggest dramas in this saga. Remember all the communications they had on that app? And allegedly, many of them are gone. Therefore, the untraceable smear campaign is truly untraceable. They can't prove any retaliation. They ain't got no evidence. Or maybe they ain't got no evidence because all the evidence we have seen thus far exonerates Baldoni and the Wayfarer defendants. I remember flashbacks, seeing numerous texts and emails from Justin Baldoni and even the publicist and crisis communications expert saying, we didn't plant that. This is organic. This was all way back in August of last year. I also saw communications from Baldoni saying, I don't want any negative stories about her out there. Yes, there were communications with the media, but it was just to correct false narrative. It wasn't to smear the very smearable Blake Lively. The judge continues. With limited exceptions, the Wayfarer parties oppose the motion to compel because the court cannot sufficiently assess many of the Wayfarer parties' claims of privilege based on the contents of their privilege log. The Wayfarer parties are directed to file a more complete log as further detailed below. All right, don't worry. I'm going to speed read the next part because I don't know how exciting it's going to be. It's Judge Lyman. And we already got the gist of it. Submit a more detailed privilege log. All right, here we go. On August 27th, 2025, the court issued a memorandum and order addressing a host of discovery issues raised by Lively in an omnibus motion to compel. Among the issues addressed in the order was Lively's contention that the Wayfarer parties should be directed to produce a privilege log for documents or communications created after December 2024. The Wayfarer parties opposed this request. In its order, the court directed the Wayfarer parties to produce a categorical privilege log in accordance with Local Rule 26.2. The Wayfarer parties subsequently did so, after Lively contended that the amended log contained many of the same deficient descriptions as the original one. The Wayfarer parties agreed to provide a document-by-document privilege log, which is now the subject of Lively's current motion. Lively asserts that the privilege log is again deficient in several respects. For example, the log does not indicate senders or recipients of each communication, but instead lumps participants into certain categories. Lively argues that this approach prevents an assessment of the propriety of each claim of privilege, as it is unclear who is communicating in each document. Lively also seeks production of certain categories of documents which she believes plainly are not privileged. A privilege log must contain sufficient information to enable other parties to assess the claim of privilege. The log provided by the Wayfarer parties in many instances provides the court with insufficient information to assess the claims of privilege. First, Lively asserts that the Wayfarer parties should be ordered to produce all signal communications and attachments lacking an attorney presence. The Wayfarer parties respond that an attorney does not need to be a sender or recipient of a document or communication for the attorney-client or work product privileges to attach. What matters is whether the non-lawyer communications are necessary or at least highly useful for the effective consultation between the client and the lawyer, which the privilege is designed to permit. Certain entries in the privilege log appear sufficiently detailed and related to the provision of legal advice to qualify as privileged, while it is less clear whether others do. For example, some of the communications, such as privilege log items 421 through 451, include the presence of law clerks Spencer Friedman and Jared Friedman, and would therefore appear to be privileged unless those individuals' presence was incidental to the provision of legal advice. The Wayfarer parties also argue that some communications are categorically privileged because they were made between corporate employees for the purpose of implementing legal advice and obtaining information to support counsel's legal strategy. Although it is true that communications among corporate employees are privileged where the communications are intended to give professional advice to those who can act on it or to provide information to the lawyer to enable him to give sound and informed advice, the privilege log is insufficiently detailed in certain places to determine whether, as to the particular chat, that is in fact what the relevant communications were designed to do. In places, the privilege log contains only general descriptions regarding corporate employee communications involving claims in Lively's lawsuit and parrots the legal standard by asserting that these communications were in furtherance of legal advice. It is the Wayfarer party's burden to establish those facts that are the essential elements of the privileged relationship, and conclusory assertions that these communications were necessary to seek legal advice fail to meet that burden when those assertions are not specifically tied to particular aspects of the litigation. As an alternative to ordering production of the materials, however, a court may direct the party producing the privilege log to serve an updated and corrected log. The Wayfarer parties are therefore directed to update their privilege log with the information necessary to substantiate their claims of privilege, including by specifying not only chat participants, but also message senders. Thankfully, the judge is telling them explicitly how to correct this, so it should hopefully be an easy fix. And lawyers are worth every penny. I would hate to be a lawyer. Exhausting. And not, I guess some lawyers are passionate about what they do, but so much of legal work is this garbage. The judge is not done, though. Lyman continues, a similar point applies with respect to a second category of documents, those where the privilege log indicates that the communications were made seeking legal advice regarding media strategy to support litigation objectives. As the court has previously explained, a media campaign is not a litigation strategy. Some attorneys may feel it is desirable at times to conduct a media campaign, but that decision does not transform their coordination of a campaign into legal advice. Here, the Wayfarer parties assert that the communications did not simply concern media and PR strategy, but were specifically seeking legal advice regarding those activities. The log does not identify message senders. In addition, although some of the descriptions tie the seeking of legal advice to something concrete, such as preparation of amended pleadings, other descriptions are more general and conclusory, such as those involving ongoing litigation strategy, including coordinated media and communication strategy in support of litigation objectives. These latter descriptions are insufficiently detailed for the court to ascertain whether any particular communication principally involved the provision and seeking of legal advice or instead was merely related to media strategy concerning litigation. They should therefore be supplemented. Third, Lively requests in-camera review of 12 documents where there is an attorney present because the descriptions of the documents are, in her view, insufficiently particular to enable her to assess the Wayfarer party's claims of privilege. 4 of the entries concern an internal investigation, which the Wayfarer parties have since indicated was the internal investigation by Raines Feldman Luttrell LLP, and which the court has previously ordered need not be disclosed. The court reaches the same conclusion here. Yay! I'll take every win, little as it may be. A win is a win. The other 8 documents are voice note attachments, which the privilege log describes as made in furtherance of legal advice. The court holds, for the reasons provided above, that while some of these descriptions are adequate, e.g. those tying the communications to a specific legal issue, such as the implications of communications obtained by the New York Times. Others are not, e.g., those generally related to evidence gathered and work product involving the litigation as a whole. In addition, once again, the log does not indicate message senders. Finally, this woman is exhausting. Lively seeks attachments to certain signal communications, arguing that evidence transmitted to counsel, especially evidence that existed prior to litigation, is not entitled to protection under the attorney-client or work product privileges. The Wayfarer parties assert that most, if not all, of these documents were already produced, but that to the extent any have not been produced, they will be. The Wayfarer parties are accordingly ordered to provide an updated privilege log by November 25th, 2025, substantiating their claims of privilege and addressing the deficiencies identified in this order. The Wayfarer parties are also directed to provide the additional attachments by November 21st, 2025. Lively shall have until December 1st, 2025 to make a renewed challenge to the claims of privilege. The clerk of court is respectfully directed to close the motion at docket number 889, so ordered. Thank God for that pre-workout drink, or I could have not made it through that. The goddess of garbage. I like it. That's a new one. But you know what is not garbage? My cameos. I love making personalized videos for you all. I have thousands of glowing reviews. Get a cameo from me for whatever the occasion. Perfect for the holidays. Right now on the Cameo website at cameo.com/myname. P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. You can read my website for free every day throughout the day, and it's an awesome way to support. Check it out right now. It's myname.com. Perez, Hilton.com. Also, I have beautiful Grab Your Friends, Wear Your Florals merch, Team Truth merch, I Organically Dislike You merch, Free Perez, and so much more, including Greater Than My Haters, Come Correct, and you have to check it all out right now at my official merch store, buypopstuff.com. That's buypopstuff.com. Plus, I know you love my podcast. We've got a Patreon where my co-host and I are super hands-on in the message board, and you'll get an exclusive episode a week. Sign up right now at patreon.com/myname. P to the E to the R to the E to the Z to the H to the I to the L to the O to the N. It's like yodeling. If you watch till now, you are the VIP of the VIP. You are the 1% of the 1%. You are a superstar to me. I mean it with every fiber of my being. Thank you, thank you, thank you, thank you, thank you, thank you, thank you. If you want to support even more, hit that like button. Hit that like button. Hit those like buttons. Hit your like button. That signals that you enjoy my content and want to see it more. And leave a comment down below that also does the same. Signals that you enjoy my content and want more. Say in the comment section down below, garbage. Garbage. Thoughts on these two waves that we discussed? I was going to say motions, but they're not both motions. One was a ruling, the other one was an objection. Team Baldoni Wayfarer was not having her request for an extension, so it was a response to her motion, and this ruling by the judge. We covered a lot. Let's discuss it all in the comments. Say garbage. I love you. I am gonna go do some breath work now. Thank you. Bye.